Have a seat, please.
Good morning, all. Today we have a trial in the matter of CFI-020-2017 before His Excellency Justice Shamlan and Sawalehi. The claimant is represented by Mohd Ammar, lead counsel from Beit al-Hikmah lawyers. The defendants are represented by Maria Rupert, lead counsel, assisted by Amanda Lewis from United Advocates Law Firm.
All right. Shall I start with asking the claimant before your opening statement? This authority bundle just came in, right?
Yes, Your Honor.
Which is unusual way for submitting this in the court before the hearing, 5 minutes. So, any reason for that?
Yes, your apologies, Your Honor. The authorities bundle was printed out yesterday evening at around 6 o'clock, and the reason for that is we had only received the defendant's skeleton arguments at about 3:45. The reading, the authorities bundle just sets out the documents that are referred to in the skeleton arguments. They're there for convenience more than anything.
Yes.
The relevant parts of the authorities that are cited are already provided for in the skeleton arguments. We have just submitted them as a matter of convenience.
Okay. My second question for the defendant, can you explain why the skeleton argument came very late before the hearing? 3 days normally we receive it. So there is any reason why your skeleton argument came very late yesterday?
It was in the case management. He distressed the deadline, 4 p.m. yesterday.
It was a deadline for yesterday?
Yes, 4 p.m. in the case management.
Fair enough. All right. I've seen here the timetable for the trial. This trial was fixed for 2 days, for today and tomorrow. But if it is convenient for both parties, if we can do it for 1 day, if it is need to extend it for tomorrow, I'm free to do it tomorrow as well. But I've seen the timetable for trial. It's here. I don't know if both parties have seen this one.
Yes, sir.
This is submitted by you. You've seen this, right? Mm-hmm. So are you agree with the timetable here? My understanding, this is for 1 day.
That's correct.
Right? So are we planning for having 1 day trial now, or yeah?
I don't think so.
Yes? Just I want to make sure that on record. The only missing part of this timetable is where your counterclaim came in, because the defendant already have a counterclaim, and I haven't seen in this timetable any session for your counterclaim. Oh, this is going to do it with the defense?
I can do it with the defense. That was the plan.
Oh, yeah. So you don't have any adjusting, or you don't have any comments on the timetable? All right. So let's begin with the claimant, and we'll take it as it is scheduled in the timetable for the trial. Go ahead.
Thank you, Your Honor.
Right.
Your Honor, the claimant in this matter is VTJ Limited, a Sawalehi offshore free zone company, and the defendant is Mr. Mohd Ammar Al Hassan. This matter the claimant proposes is a matter of fact more than it is law. The claimant claims that he had entered into an agreement with the defendant on the 19th of April 2012, and that this agreement was for the sale and purchase of a unit in the DIFC, commonly referred to as DFR P430. For the purposes of this hearing, I'll be referring to it as the unit. In essence, the claimant's argument is going to be that there was an agreement, in fact, that the MOU was a binding agreement, and that it had complied with all the provisions, all its obligations, and performed the obligations under the MOU, and that the defendant has failed to perform his obligations. The defense has raised the question of fraud, which the claimant refuses outright. But should the court entertain such an argument, the claimant's secondary argument would be that the conduct of the parties in dealing with the unit indicates and creates an agreement by conduct, which is where, again, it will be a factual and a legal analysis that Your Honor will have to carry out. The defense has argued that there is an agreement dated
September.
That's right, September, and points to this agreement as creating some kind of obligation on the claimant to pay a sum of approximately 180,000 dirhams. The claimant rejects this argument. The claimant notes that there was no agreement for a deposit payable. There was no agreement on September 2014. The claimant will also argue that the sum of money that is being sought is held with Allianz Real Estate, a company that no longer exists, and not with the defendant. And therefore, the defendant's counterclaim should be dismissed. Your Honor, this matter really will ultimately come down to the facts, I believe. And it is for that reason we believe that great importance and strength and value should be given to the witness statement of the claimant, Mr. Chiro Ariana, who was, for all intents and purposes, the agent that was overseeing this transaction. And the claimant would just like to remind the court, ultimately in the end, that if what the defendant is arguing is to be taken at face value, then there is no explanation for the original documents the claimant has in its possession. There is no explanation for the knowledge that the claimant has. And for those reasons, the claimant's claim for specific performance, that is transfer of title of the unit, should be granted to the claimant. Alternatively, if there are no grounds for specific performance in this matter, the claimant requests damages in the sum of approximately 1.9 million dirhams. And in the alternative, if damages cannot be awarded in lieu of specific performance with regards to the MOU dated 12 April 2012, then the claimant would request that the agreement by conduct be deemed terminated and that it get awarded restitution for all payments made on the property, plus costs. Thank you, Your Honor.
You want to call your witness now, or I'm following the schedule we have here. After the opening, you want to call your witness?
Well, Your Honor, it's I leave that at your discretion. If you would rather have the defendant make their opening statement, or if you would rather...
I'm flexible with both parts. You want to make your statement now, or you want to deal with the witness first? I'm just following your agreed timetable for the trial. So you want to, yeah?
Perhaps I can go ahead.
Yes.
And then we'll have witnesses.
Please.
Yes. Thank you, Your Honor.
My name is Maria Rupert, leading counsel for our client, acting as defendant today, Mr. Mohd Ammar Al Hassan, a Syrian national with over 30 years of residence in the UAE. As I go over my intervention today, I will be referring to the documents in the trial bundle. Today we represent our client, Mr. Ammar, who acts as defendant in his capacity as owner of retail unit DFR P430 in Damak Towers. Our client purchased this unit on the 29th of March 2012 from Damak directly, and there was an intention to resell, which was gathered in a document dated 9th of September 2014, the MOU. No payment was received afterwards, And this is the reason why the transaction failed. The claimant, in turn, refers to a document apparently dated 19th of April 2012 and claims that payments have been made in furtherance of a verbal agreement. The claimant, as it was just mentioned, seeks specific performance, the title to the unit, or restitution of the payments purportedly made towards the purchase of the unit. Our client, defendant, what we are seeking is a counterclaim in reference. I will be guiding you to the specific points in the documents. This is just an overall introduction, seeking the 75% of the deposit that was paid by the claimant at the time. We are before a very interesting case. We have two documents lacking the signatory formalities, both of them, we will go over it. There are no payments, no records. The payments do not match any of the documents before us. Purported payments, that is. We have agents that appear to act on behalf of two parties. We have files lost by developers and by the DIFC Registry. We are before a very interesting case. We have, and moreover, if we consider that the parties, all of them are familiar with the real estate scheme. The claimant raises a very interesting question in paragraphs 24 and 25 of its reply. First, accuses our client of taking advantage of the system, and in support of this accusation says, well, we have original receipts. How could it be otherwise? We'll hope to get to that by the end of our intervention today. Before we get to that, we need to take a look at the events that leading to where we are today. Our client purchased, as we were mentioning, in March 2012. In 2011, he had met Mr. Ciro Ariana, who had proposed this unit as an investment. He could help in the purchase. It was a good investment opportunity, and he will be happy to help with the resale. If we go to page 220 of the bundle,
page or tab first?
tab number
I can go by page
220.
220.
This is what actually took place. There was a proposal. Our client agreed with the proposal and purchased the unit on the 29th of March 2012. And Mr. Ciro Ariana was registered with DAMAC as agent for our client. We have in front of us the DAMAC Know Your Customer form. So we see the name of the defendant one, Mohd Al Hassan, and then we see here below the name of the agent, Mr. Ciro Ariana, with ID number, the property. What happened?
Sorry, this is the agent of DAMAC?
This is the agent for our client at the time of purchase.
I see.
When the,
Yes.
Okay. So, Mr. Ciro, as his agent, as our client's agent, helped our client in making cash payments, taking care of administrative actions like preliminary registration, etc. Our client was giving him the funds in cash because he had recently undertaken 2-3 sales of real estate property. This was known to Ciro, and this is the reason why he proposed. I have some title deeds showing the dates when these properties were sold. I have copies if you want them.
We have a copy of those?
I don't think they are in the file. I thought it would be important to. In any event, I'm okay if you don't take them right now. It's a way to show that money was coming in cash for a reason. That's all.
Your Honor, I apologize for interrupting opening statements, but this is new evidence that was brought to our attention just now. We have not been given.
We have no problem. We have no problem. We have no problem.
Okay.
So this is the reason why money was paid in cash, because there were 3 units that had been just sold. So around 2014, in the year 2014, Mr. Ciro informed our client that there was a specific party interested in buying the unit. And this was gathered on the 9th of September 2014 in the MOU. no payment was received, the transaction failed. This is our client's story. Now I will be making reference to the claimant's story to point out some points that, in our belief, show the weakness of the claimant's case and how illogical it is. If we go to page 16 of the bundle, we are going to have before us
Yes.
the SPA, what we call the SPA dated 19th of April 2012, document on which the claimant relies on. We noticed that there is a booking deposit of $373,500, and there is a potential deadline by the 30th of November 2012. Right? We also noticed that the purchase price is $1,867,750, right? If we go to page 178, which is the document on which we rely, sorry for the back and forth.
178?
Yeah, 178. We have the MOU, the document on which the defendant relies. And we notice that there is a deposit of $180,000, and the purchase price is $1.8 million. So the question that we ask is, why would the defendant recognize, because the defendant recognizes and accepts that he wanted to transfer the unit, but why would he recognize a MOU with a lower price and a lower security deposit? Why? In addition, the monies that the claimant is claiming to have made do not match the documents. If I may guide you to page 9, paragraph.
Yes.
No problem.
Page 9?
Yes, paragraph 11. We mentioned here that there was a check in the amount of $272,000 on the 20th of May 2012, direct cash deposit 26th of July, direct cash of $141,000 on the 26th of July, cash deposit $282 on the 2nd of October. The last one, for example, the direct cash $337,500 on the 3rd of February 2013. Very good, we can go over all of them. But if we go to page 16 now, we again have the MOU in front of us, the SPA in front of us, what we call the SPA, that is the document the claimant relies on. If we look at the payment terms, they do not match. They do not match. The figures do not match.
Okay.
And the amounts, if we go to page 17, point D, it says that payment should be made by manager's check or transfer or via transfer. We are not saying that funds were not received in this form. We are saying that funds were not received in any way or form, not even cash. There was an intention on the part of our client to sell that unit. That's not denied. There is not only uncertainty on those aspects, there is more uncertainty. The claimant doesn't know where the monies came from. If we go to page 253 of the bundle, 253. We have an application seeking information on, seeking to recoup the account statements of Allianz.
Just 1 second, sorry.
Yes.
253. In the
Second paragraph.
No, in 253 I have the case management order.
Order, yeah, there is an order.
Oh, yes?
Yes. So here it shows that the claimant does not know where the accounts, the monies were coming from. They don't know if it came from Banco Reserva, Banco Progreso, Banco León in Dominican Republic. No idea. Not only we don't know where the monies came from, and we are talking about a nice chunk of money, we don't know where the monies came from, we don't know where the monies went to. If we go to page 207.
207?
Yes, 207, please.
Yes.
Paragraph 8, this is Mr. Siro's witness statement. It says, so all payments to Ammar and Mohammed were made in cash. VTJ arranged for transfer into my personal account and to the account of the broker Allianz Real Estate. Then this will be deposited to Ammar. We don't even know where the money went to. We don't know. Not only we don't know where they came from or where they went to, we don't know how much was paid. If we go to page, if we stick to 207, if we add the amounts that Mr. Siro claims that he paid, this adds about 1 million dirhams, okay? But if we go to page number 9 of the bundle, number 9 of the bundle, the amounts claimed by the claimant in the claim add to about 1.386. Again, no receipt of any way or form for the amounts. We don't know what are the amounts being claimed. There is a few other uncertainties. One that I would like to point out is the fact that we read that the transaction did not take place in May 2014 because there was some confusion with the fees payable to the DIFC registry. Apparently, they were supposed to pay 5%, but they paid 3.5%, and then everything got complicated. Well, the regulations on that is publicly available, but it changed before May 2014. The 3.5 was raised to 5% way before May 2014. So this is also, it's a small point of uncertainty, but there are parts of the story of the claimant that do not flow. It just does not flow. So do we have, the question that we are asking ourselves is, do we have a meeting of the minds? Well, there is the intention on both sides to sell. One party is relying in one document, the other party is relying in the other document. What are the specific terms? The date of transfer, the purchase price is different. How do we do that? I mean, how do we chew it? Moreover, if we pay attention to the fact that both documents have funny, strange, interesting parts in their signature, the defendant is claiming that the only document that he saw was the MOU of 9th of September 2014. But let's pay attention to the SPA. Please follow me to page 18 of the bundle. If we take a look to the signature of the second party, the claimant,
Yes.
where is the stamp? I don't care so much about the stamp. Where is the board resolution? What is the name of the authorized signatory? POA, this is a JAFSA company. This is how it works. You need a certificate of incumbency, you need a board resolution, and you need a power on behalf of whoever is going to represent the company. Where is it? And I'm no expert, and I am exceeding, but if we take a look at the handwriting, it will be very easy to sign on behalf of one party or the other, because there are no formalities on either document. The document the defendant relies is not countersigned, as promised by the agent, but this one is signed by we don't know who. Again, we are not saying that a contract could have been made by conduct. It could have, but we have no payments under the MOU or the SPA. No payments on record. All we have before us is cash receipts on behalf of the defendant or client. Page 221 of the bundle shows this very clearly.
Twenty-one.
221. This document was received by Mr. Zero at the time of making payments on behalf of our client. And if we go to the second paragraph from the end, it's clearly mentioned that it says, we hereby declare that this payment is being made solely for and on behalf of the buyer, and we shall have no rights or actions against you for the said payment. This is signed by Zero Ariana and needs to be read in conjunction with the Know Your Customer form that we went over a few minutes ago. And this accompanies every single payment that Mr. Zero made on behalf of our client. So, based on the case, on what we have in front of us, the defendant can but claim the 75% of the deposit that was deposited with Allianz, but this was the penalty that the claimant undertook to pay if they withdrew from the transaction. The 75% of 180,000 dirhams is about $36,000, and the legal costs, of course, in about $63,000. So let's go back to the question that the claimant poses in the reply. Our client, the defendant, is abusing the system because the claimant is in possession of payment receipts that we have seen how they were collected, because Mr. Zero was our client's agent, was registered with Ammar as our client's agent, and the payment receipts show that the payment receipts were made on behalf of our client. One more thing that shows that our client's position is stronger, because it is if we go to page 208, again to the witness statement of Mr. Zero Ariana. And 208. The reason why the claimant explained, and we will be looking to paragraphs 17 and 18. Here, what it said is, well, we could have completed the transfer, but the DIFC was not satisfied with how payment had been made. There was one way to solve it, and this was to prepare a manager's check to give it to the defendant, and then if payment was already made, they could have just torn it into pieces, that management. But Mr. Zero says that no, that was too risky. Less risky than making payments on behalf of someone without documented that the payment was being made on their behalf. I'll tell you why it was risky. Because he knew that the defendant or client had not received payment. So he knew that if he handed that manager check, it was never going to come back, because payment had not been made to our client. That's why it was more risky for him, perhaps. And that's the end of my presentation. Thank you very much.
Well, I guess then this is the right time to call the witness.
Thank you, Your Honor. We call Mr. Zero Ariana.
Yeah, if you can come to the witness box.
Zero Ariana.
And what do you believe?
Christianity.
I swear by Almighty God
I swear by Almighty God
that I will interpret the evidence
that
I will interpret the evidence
that I will interpret the evidence
that will be given to the best of my knowledge and ability.
that will be given to the best of my knowledge
And ability.
and ability. Thank you.
Yes, Your Honor, I was just a small matter of housekeeping. Is there a copy of the trial bundle for the witness box? If there isn't, I have one here and I'd like to submit it.
I don't know. Yeah, you can give it to him. Sure. I'm not sure if he has a copy of it.
Mr. Ariana, can you please turn to page 205 of the bundle in front of you?
Yes, please.
Is this your witness statement?
Yes.
And can you please turn over to page 111 of the same document? 211.
211.
Is that your signature?
That's it. Yes, it is.
Your Honor, we submit the witness's expert. Oh, sorry. And did you? Is this your written witness statement?
Yes, read, approve, and sign. Yes.
Your Honor, I submit pages tab B1 as the claimant's evidence in chief.
So you don't have any specific questions?
Your Honor, I do have some questions, but I was
after the cross-examination?
Yes, but if it's okay with the defendant.
Yeah.
Mr. Chair, just a few questions for
Please.
you. You state at paragraph 1 that you are a close friend of Mr. Tommaso Ambrosio and Mr. General Ambrosio.
Yes.
At the who are directors of VTJ Limted. You state that you acted in a personal capacity to manage VTJ's business interests and investments in the UAE. Just at the time of this dispute, of the purported dispute, who was your employer? We understand that you're talking in your personal capacity, but in a professional capacity, who was your employer?
Mr. Ammar Meraji, owner of Allianz Real Estate.
Okay, right. So you have the. And you have, so that means you've had previous dealings with Allianz. That's right.
Yes.
Sorry, Your Honor. Just how would you explain your relationship to Mr. Hamad Saeed Maraji, who you referenced in paragraph 2? Sorry.
My relationship with him?
Yes.
He was a friend and I was working with him. I know him since 2008. And from 2009 we started to work together. But since I was in visit visa, I was not registered anywhere. But I can prove this because I had the fine from RIRA in 2013 that I was working with Allianz without the RIRA card. So the fine can prove I was working with them, along with the mail, company, and everything else.
Okay, so just to clarify, your relationship with Hamad Saeed Maraji, you were
Partner, broker, everything.
Mr. Chiro, paragraph 9, you referred to a number of payments that you made to Dalak.
Yes.
Now, can you explain to me why these payments were made in cash?
To the MAC? Yes, okay. The money was receiving from my client from Dominican Republic. If you can check the account of Allianz Real Estate, you will see the money receiving, same time withdrawing, and me making the payment. I never received a single penny from Mr. Ammar. And when I used to go to the MAC, I can prove that receiving mine Allianz from Dominican Republic and pay over there. Also, there is 2 checks paid to the MAC from Allianz Real Estate with the bank account of Allianz that we received the mine Allianz, and Mr. Ammar, don't withdraw too much cash, he gave me check and I pay on behalf in the MAC on behalf of my client. Because the agreement was, he purchased the property, I continue the payment and giving down payment. On transfer date, I will give his profit to him. And one thing I want to say, in 2014, we signed an NOC in Damac. Me, Mr. Ammar, Renata from Damac, and 2 other witnesses, which he signed the NOC that he received the full amount as no objection to transfer the property. Along with that, we issue a check from Theodore Wessi, our previous lawyer, of 3.5% to DFC court in order to transfer the unit. He never paid even for transfer fee, we paid for everything. And the payment I made to Damac, they're all matching the arrival of Allianz Real Estate statement. I never took a single penny from this gentleman and paid Damac on his behalf, ever. Along with that, 2014, we paid the penalty for delay payment, me, Mr. Tommaso and Mr. Angelo, to Damac, to Miss Hilda, Palestinian lady. She received the payment, we did the negotiation because everything was belonging to us. Otherwise, we are not paying penalty for Mr. Ammar.
And the payment of the penalty, that's the... is that, in terms of the negotiations you were talking about, is that the email that was
Yes.
sent to you? Sorry, I just want to make sure.
Please.
Over on page...
Maybe you can see the reference you are looking for.
Yes, okay.
You can show the witness, you can confirm.
Sorry. Over in the reply to the defensive counterclaim at page 184.
184.
Yes, page 184.
184. I have a claim for
Sorry?
page 184
Yes, page 1.
from the bundle. Are you
Sorry.
looking for bundle? The page number of the bundle. no?
Oh, yes. Page 184 of the bundle. Yes, that's right.
Yes. Yeah, five.
And I'm sorry, I got the page wrong. I mean page 195.
195.
Exhibit VTJ 15.
Yes.
When you say you were negotiating the penalty payments, are you referring to this email and the attachments from at your service at Damac Properties to Ammar 386 at EIN.AE?
Exactly.
And then the subsequent email that he had sent from Ammar, dated 26 February 2014 to Ariana Chiro.
Yes.
And the penalty payment would be the customer request form at page 199. Is that right?
Yes.
Okay. With regards to the source of payments, we've heard that they came in from 3 separate bank accounts. Now, you have had personal dealings with the Ambrosians. Sorry. Can you possibly shed some light as to why payments were received from 3 different bank accounts?
Look, payment, he has different companies around the world. So he never sent money from Italy, always been sent from Dominican Republic. But all the money has been sent in Allianz Real Estate account. All the amount that was there. And the payment made to Damac are matching the arrival in Allianz, along with the check made from Allianz, paying on behalf of my client to Damac.
Just a few more questions, if
Please.
you want, Chair. So you were employed with Allianz.
Yes.
You were a broker registered with Allianz. And you had worked with the Ammar.
Ammar Al, yes.
And prior to this matter, had you worked with the defendant?
With Mr. Ammar? No, he was in our office. They sold a couple of his property in our office. He was sitting there doing some work on the stock market or whatever. So let's say it was a kind of friendly relationship, But then when the gentleman realized that the property legally by NOC, because the file were lost, was coming in his name, he started to argue to get property on his behalf, where he didn't pay a single dirham for that.
Now, just a final question, Your Honor. Can you explain how it is that Damak had lost the documents? Is there any, have they provided you with any explanation?
No explanation, but in Damak, you can call that there is Renata Maldad. She was in charge of the NOC and transfer. We signed it, Mr. Ammar signed an NOC in front of me, Renata, and two other lawyers, mentioning that he has no objection transferring the property because he received all the money. And once was that, apologize.
No, you can have some water if you like.
No, I just want to thank you so much. Once was that he signed that he received the full amount, has no objection on transferring the unit. And when we went to the DIFC to transfer, along with the check from Taylor Westing from our side to pay the transfer fee, they say, sorry, we don't have any file. Because the file was lost, because between the DIFC, we signed only Damak. They don't give us any document, Damak. Damak send directly document to the DIFC court. Then we go to the DIFC and finalize the agreement. So we didn't have any documents in hand. But there is 4 witnesses, 2 from Damak and 2 from our lawyer who can testify that we were there and he signed everything.
And you know this from your dealings as a registered agent with Damak?
I know, so sorry?
Let me wonder. Are you registered with Damak as an agent?
Yes.
And you've disposed of, you've overseen property transactions with Damak property.
Yes.
Before. And the process you've just described, whereby they would send original documents to the DIFC registrar or the land department or whichever authority, is that standard? Was that standard in your dealings with?
No, with DIFC was in this way. The developer transferred the file directly to DIFC and we come for transfer. If it's some other like land department, they hand over the documents to us and we're gonna go to land department, make the transfer with everything else.
I have one more line of questioning, Your Honor. Can you talk me through this meeting that supposedly happened on, the meeting that has happened on April 2016 at the
Sofitel.
Sofitel. It's the Sofitel, not the movie.
Yes.
Okay. At the Sofitel. Can you just talk me through what had happened at that meeting and who was present?
Okay, there was Mr. Tommaso, Mr. Angelo, and there was another lawyer, Stefania Santanello. They met Mr. Ammar, but they say, I don't want to meet Ciro because Ciro is the truth, I don't want to meet me. He requests for them, they can witness, 400,000 dirham. Say, look, I will give your property back in exchange of 400,000 dirham.
Sorry, this is 400,000 as a part payment, or?
No, because he said that some other property that we sold on his behalf in 2011, when the market was down, we sold for lower price when they were more expensive. So he requests his money back. After this meeting, after 10 days, he came to my office in Conrad Hotel. I meet him again. I say, how are we gonna do it? He's like, pay 250, we will sort it out. There is camera and all the time. Pay me 250,000, I'll give you a unit back. You know I'm a gentleman, I do these things. Then he started to answer my phone again.
Okay, so.
And one more thing, I got several messages from his side telling me, it's better you drop the case, otherwise you're gonna go in trouble. I say, why gonna drop the case? I got status, his messages, please drop the case to court, otherwise I'll send you in trouble, I will ban from the country and everything else.
So these are messages that the defense.
From Mr. Ammar to my mobile, I got everything registered.
Okay.
Like threatening me to drop the case. And I told him, I'm a broker, my client won the case, I cannot do anything. I can prove everything by phone.
Your Honor, I don't quite. Okay. let me rephrase the question, Mr. Ayala. When you had met with Ms. Stefania Santanello at the Sofitel and the defendant and the Ambrosios, who are the directors for VTJ, just for clarity's sake. The 400,000 he had asked for, that, are you meaning to say that that was an excess payment?
An extra payment, of course.
Okay. And that he had contacted you and sent threatening messages about proceeding to
the court case. And along with that, Just I want to say, 2013 and 2014, we've been paying the bill of Empower, because the property was there, not transferring yet. We have the receipt that we paid Empower bill. Why we should pay Empower bill if property belonged to him? Was already belonging to us to transaction to MOU which was signed. Why I should pay Empower bill? Why I should negotiate with the MAC penalty if property doesn't belong to us? We pay the bill. We mail back and forward the MAC. We've been with VTJ negotiating with the MAC. We pay the penalty cash in the MAC. Why we should do his job if it's not our property?
So when you say we, you mean VTJ?
Me, Tommaso, and Angelo, the two owner, father and son of VTJ.
The father and son.
Yeah.
Okay. So you were overseeing as both the agent for the defendant and as the agent for
Exactly.
VTJ.
Yes, and another thing, sorry. He's proving that there is an MOU 2014. There is easy mail sending to my email all documents on the MAC. Why should you send me this document if there is no relation to MOU signed? Why would you send me documents and say, I received this thing, I got email and message, I received these things, come to pick it up. I received this mail for the MAC, check what they want. Why? If it's your property, we didn't give you anything. Why you should do that? He cares so much.
Thank you very much, Giro.
Most welcome.
Well, thank you. The defendant.
Hello, Mr. Ciro. Before I jump into my questions, I would like to give answer to that question because you were registered as his agent.
I was registered in the MAC as the MAC agent, that I bring the client and they pay me commission. We don't get registered to developer as a broker or someone. I was broker of
Online,
Allianz.
I'm receiving all communications through you, okay? But let's get to that. Don't worry. I will be going through your statement.
Yes, please.
You mentioned that you are a personal friend of Mr. Tommaso and Mr. Angelo, and you help them in a personal capacity. What do you mean that you help them in a personal capacity?
What do you mean personal capacity?
You mentioned here, you say, I act in a personal capacity to manage VTJ's business interests and investments in the United Arab Emirates.
Exactly,
What do you
yes.
mean in a personal capacity?
Personal capacity that they have a trust on me and faith on me. When there is a good investment to do, say, Sheila, there is something good, yes, there is these things. They transfer the money, I'll take over the transaction. I sold another 4 or 5 property for them.
So that was my next question. How many transactions have you helped them?
4.
Only 4?
Yes. Burj Khalifa, Marina, and a few others, yes.
Okay. Then I would like to jump to paragraph 6 of your statement.
Which page, sorry?
206. And you say, in early 2012, I had identified a potential investment. How early in 2012?
What do you mean, sorry?
You say early 2012.
Yeah.
How early? I mean, for you, what is early in the year?
Early year, the first and second quarter, I consider it early. Before June, I consider it early.
Okay. If that was the case and they were your close personal friends, why didn't you recommend them to buy the property directly? Because Mr. Ammar bought it in March 2012.
Because Mr. Ammar bought it in 2012 and I offered to my client in April because I know it was a good investment. I asked him, I told him, I have a buyer, I take forward the MOU in April.
And there were no other units available?
Nothing available. It was the last units available was as retail in the MAC. Otherwise, I was direct over there. You can check also with the MAC if there was unit available at the time. There was 2 more units, one he took it and somebody else took another unit.
No, I'm only asking questions in respect to your
Please,
witness
please.
statement.
So
Okay?
March he purchased,
That's my-
April I offered to my client. Because he
That's
was in
fine.
the office, we were communicating, I say I have a buyer for that.
Then in paragraph 8, page 207, you claim that monies were transferred into your personal account.
Sorry,
Now,
which paragraph?
paragraph 8.
8. Okay.
It says that transfers were made into your personal account and the account of the broker Allianz.
No, I think there is a mistake because money was sent all to Allianz Real Estate. I was not resident, I had a personal account, I could receive a lot of money. So I give you for guarantee that all the money has been transferred to Allianz Real Estate.
So are you suggesting there is a
So
mistake
this is a mistake, yes.
in writing? There is a mistake in fact? or
Yes, mistake in fact, not in my account, all in Allianz Real Estate. Sorry, Mr. Mayer, but too many things.
Okay.
In paragraph number 9, you say, I have been presented with a number of documents provided to me by the developer, which specify the payments I made for the unit. I made for the unit on behalf of VTJ. Again, I would like to draw your attention and guide you to page, I'm almost there, page 221. 221, the paragraph I read before, I'll read it once you are ready.
221, yes.
Yes, because it says, I will hereby declare that this payment is being made solely for and on behalf of the buyer, and
Wait
I
one second.
will shall have no rights or
Sorry, 221.
221, the second paragraph from the end. I will hereby.
Yes, okay, see.
I will hereby declare that this payment is being made solely for and on behalf of the buyer, and I shall have no rights or actions against you for the said payment. And this is read in conjunction with page 220. When you made a payment of 300,000, you are registered as agent for Mr. Ammar. What I mean, you have a personal connection to the claimants. By signing this and not documenting it, what were your thoughts? What crossed your mind?
Not crossing my mind. It was a friendly relationship with Mr. Ammar. So the agreement was he purchased the unit, we resell it, he was going to make some profit and take it forward.
But yes, but
then,
actually there was an agreement. I'll take the SPA 1 that you mentioned that you are relying on. Why in that document, it's about 3 pages, why in that document, in page 9, I mean, I could understand that you page 16, sorry. I could understand that you say everything is verbal. Everything is verbal. We agreed and this is how. But no. In page 16, you have an SPA.
Sorry, 16.
16. Yeah, you have to go at the very beginning. Page 16.
228. No.
16. Go to the front. You say that everything was verbal, but you have an SPA that the claimant is relying on. What would have been the effort in putting here? There is an original SPA with the developer. The claimant, VTJ, is going to pay back to back. You do all of this, and then you do completely different. Why would you put something in writing to do? I'm asking you as the agent, because you were the agent for the claimant and for the defendant. You were the one who was overseeing the transaction. So I'm trying to understand how we can go from this to we don't know what we did because we were all friends. We are in a legal courtroom.
Okay.
Please.
You say that the MOU of 2012 is not recognized by you. So why you're asking me this MOU? If it's not recognized by your gentleman.
It is not recognized, but I'm trying to understand your position. I'm trying to give some sense to your position, which, in my opinion, has no sense.
Will make sense for that. Don't worry
Yes.
about it. Carry on.
Yes.
What's your question?
I'm asking, you are saying that no, everything was verbal, that you went to the MAC, you made payments, you were registered as agent on behalf of the defendant, you made payments on behalf of the defendant, but your position is like, no. I was good friends with Tommaso and Angelo, and I was making payments on their behalf, not the defendant.
Of course. And this MOU is mentioning this, that the payment is going to carry on from us.
Where?
In this MOU.
Where? Please guide me. You were the agent.
Okay.
Show me what you fabricated.
Look, in this agreement here is the payment that my buyer has to do toward Mr. Ammar.
Yes.
Okay? But this payment, instead than be going to him, since the payment was in installment in the shop, was 2-year payment, we were doing directly to the MAC. And I can prove
Why didn't you put addendum further to the MOU signed on the 19th of April? We are not going to follow the installments. We are going to pay back to back.
Okay. I can't remember how we did it. But I can tell you that this agreement was done. We take the payment from my client and pay the MAC. And I can prove this with receiving amount in Allianz Real Estate. If you can prove that he gave me any dirham somewhere, please do it. If he was giving any money, if he has some withdraw or some check in all the transaction, please he can prove it. I can prove you that all the time we withdraw money from the account were coming in Allianz account, all of them. Kindly prove me a single payment he gave it to me.
Again, let me guide you to page 221.
Sure.
We hereby declare that this payment is being made
One second.
solely.
Let me reach, please.
221, second paragraph from the end.
Okay, vai.
Second paragraph from the end. We hereby declare that this payment is being made solely for and on behalf of the buyer, and we shall have no rights or actions against you for the said payment.
Okay.
This payment was registered on behalf of our client.
Okay. Okay, let's say this payment, the first one was made on behalf of our client. Let's say because it was a little bit, let's say, I will say in a friendly way. And the rest of the payment, let's say you did this one.
All of them were, this document accompanies every single payment that you made. I am showing you only one, but if you go, you are claiming that you made payment of 280, 300, 390, and 60 something.
See, but sorry, 1 second. In this document which is over here, I don't see his name. I don't see anything written over here. What is mentioned here? There is my signature, but there is no address, there is no date. Not his name is mentioned. Where is it? I see my signature, but...
This was submitted by the MAC when you requested the MAC. This was submitted by you.
Okay.
This was submitted by the claimant to the...
Where is the complete form? Where is the stamp of the MAC?
only-
Where is his name on it? I don't see anything here. What you are giving me?
It's okay. I hear you. In my understanding, just for the record, we are using documents that the claimant has submitted in support of your witness statement. We didn't prepare these documents. We are using your documents.
Okay, look 1 second. You are giving me a paper blanket which mentions the buyer, doesn't mention his name. There is my signature. Who doesn't tell that they print my signature? There is nothing here.
She's trying to say this document already submitted by the claimant, and you are witness of the claimant.
Yes.
This is the document you sign, or you are questioning you sign?
No, my question is, this signature belongs to me, but there is nothing mentioned about his name, about the property. There is nothing.
Do you recall if you have signed this, or you cannot recall if you?
No, I can't remember because
Okay.
it's a blanket paper. There
This
is
document-
no stamp from the MAC, no other signature, no
Okay,
date.
it must be read in conjunction with this, all was submitted by the MAC.
Can I see it?
Yes, you submitted this was submitted by the claimant.
Okay,
I'm
but
only using your documents. I'm only explaining your documents.
I understand, but this document is not mentioned anything on it. They're blanket.
So the question is, did he answer your question, or still he?
What I was asking is, what was he? He answered my question, and his answer is that yes, irrespective of what is mentioned here, he was making payment on behalf of claimant. That's the answer.
All right, so let's move with
Yeah, let's move.
Yeah.
Your Honor, with
I-
due respect, sorry. They're asking about this document, which there is nothing mentioned on it apart my signature. There is nothing else.
The court understands that.
What I need to reply here?
For the claimant.
No property, no name, no date, nothing.
Sorry, we will move on. I only have one more question. In paragraph 24 of 209, paragraph 24 of page 209.
Paragraph 24.
Yes.
Let him read it if he maybe before you give him a question, so he can understand.
Yeah, please take.
Can you go through?
I read it.
Yeah, that's for yourself.
Yeah, that's for yourself.
I approached the DIFC.
You don't need to loudly, just go through it so you can understand what we're going to ask you about.
Yes, please.
My question is very simple. This paragraph makes reference to a law firm, Taylor Wessing, making payments purportedly for transfer fees. Why do we only see Taylor Wessing and a lawyer and a check in this instance? Why?
Because VTJ was registered with the power of attorney from the previous lawyer, Clotilde Yaya, that was working in Taylor Wessing. So, me as an agent, I was doing transactions in Allianz Real Estate. But when it was coming at the point that the POA or VTJ should come and sign and make a payment, was Taylor Wessing. So Taylor Wessing, after hearing from Damac, because they came to Damac office and they got the NOC, and he signed the NOC, and they got the approval, then they issued the check to pay Damac DFC transfer fee 3.5 to 5% to get the property in their name.
And why, if that was the case, because I haven't seen any power of attorney and any letter of engagement, I cannot confirm that a relationship, legal relationship was ongoing between Taylor Wessing and the claimant. But even if so, how come they would be sending payments to a real estate agency and not to a law firm if they had a lawyer?
Because the real estate agency was doing the deal with them. What is this question? They can send the money even to my lawyer, and I can take money from him. Why they should send it to VTJ, to Taylor Wessing or Allianz?
Yes.
Allianz was the agency who was doing the deal. They send the money to the agency, and we can prove the receiving money and the payment money. They can send to anyone they want. What the question? Sorry.
Yes, I'm just saying that maybe it would have helped documenting the payments.
Documents
If there is a lawyer. Another thing is not having a lawyer. But you have a lawyer, and they know you are doing what you are doing. If they know, I don't know. But it's strange in real estate transactions to have a lawyer only participating
Because there is
that
a difference. Like that the lawyer, every time they receive an amount and they gotta make some payment, they will charge the fee. Since they trust me, and I will tell them my account or Taylor or whatever, they do it through me to don't always pay Taylor Wessing all their fee. But it's registered in the POA, the court, that VTJ is the Taylor Wessing was the full power of attorney of them. And in the meantime, they were even splitting.
I haven't seen the power of attorney.
Huh?
I haven't seen any power of attorney.
We can provide for you.
And one last question:
Please.
If we go to the SPA that the claimant is relying, is in page 18. We will be looking to the last page only.
But beginning, page 18.
18. We see here the signature of VTJ. How come there was no board resolutions prepared? How come it doesn't show the name of the directors signing here?
We signed on behalf of VTJ Limited.
Who?
One of them, I can't remember if Tommaso, his father, that were here. VTJ Limited, because they were needed both signatures as they both of them they were there. But we signed in VTJ Limited because his father was not here.
So the two signatures were required, but just one person, one of them signed the name of the company.
Who said that the two signatures were required?
I don't know because I don't have the.
So what you're telling me, like two signatures were required and you don't know? Ask me a question,
No,
what you know.
what I know, excuse me, what I know, I've done about 50, 60 real estate transfers in Dubai,
Okay.
in the UAE. And for JAFSA companies, which became a very familiar vehicle to purchase real estate in the Emirate of Dubai,
Yeah.
you would need certificate of incumbency, you would need a board resolution, you would need a MOA, right? In order to, and in the MOA, you would need the name and signature of the person, of the authorized signatory.
Okay.
Then local regulations, they also, local authorities, they always look for the stamp. I don't care so much about the stamp, but about certificate of incumbency, board resolution, MOAs,
you are
need.
completely right, that is
Yes.
by the rule. All of these were brought in Damac in a date of transfer, along with the POA from Taylor Wessing. They came with all the documents. We are representing. This is the MOU, and he signed the MOC, receiving the full amount. So maybe on the MOU we didn't mention, they mentioned VTJ, but in time of transfer in Damac, everything was brought over there.
Why we are asking the witness about the formality of signing this document?
Because
What
he
is the relation?
because he was the agent.
Yeah, but he has nothing to do with the formality of signing the MOU, what does it mean by?
Well, usually agents need to prepare all the documents in order to ensure that the authorities are going to accept the documents at the time of transfer.
I understand.
Yes,
But
that's
he already been giving this document and he represented to the Ammar, so he has nothing to do with the formality or the.
well. I'm trying to stress that many things were done irregularly.
So did he answer your question now?
Yes, he answered.
Okay.
And last, I promise
Please.
last.
So before you ask, I'm going to jump on this. Have you seen before the same situation where like a more than one signature was in a different situation, different transaction?
No, I don't understand the question, Your Honor. Sorry.
From previous, because he was engaged in this transaction from the same from Alliance. Right? Have you seen a different in another MOU? Have you seen like an MOU with a two signature as he was suggesting?
Yes, with the MOU we did in different way. The more important that we weren't going to land department, DFC, we will bring the original document in order to prove it.
Right.
But company or to signature, we never give a really value on it. Till we approve that this MOU is signed by him, witness, and VTJ. In date of transfer, everything is matching over there. We knew all the documents are there. We haven't attached it, we haven't put all the form, but they were there and we provided to the MAC and the DFC date of transfer. All of it.
Thank you.
Welcome.
So you have any more questions?
Yes, one question. And this 208, paragraph 18.
208 page, yeah?
Yes.
Yes, please.
Yeah, you can read paragraph 18.
Paragraph
18, page 208, paragraph 18.
Yes, please.
Why do you think this was dangerous?
Why?
What's the question?
Because when we went
Let me paraphrase.
Yeah, phrase the question.
The question is, Mr. Ciro is mentioning that he recommended, the only thing that was missing for the transaction to take place was to prepare a manager's check to present to the DIFC registry, and then in many transactions this happens, and then they break it, right?
Okay.
But Mr. Ciro recommended the claimant not to do it because the defendant could keep the check. So I want to understand why he thought this was dangerous as opposed to making all payments without proper documentation.
Okay.
Okay.
He used the word danger.
He says will be nothing that situation will be difficult to reverse, considering that the purchase price was paid in full already to Mohammed. So they were afraid that if they gave the check, it would never be given back to them.
Exactly.
Yeah. Why do you think that would happen?
Because we lost the trust of the gentleman at the end. He started to contradict himself in many things.
But when this happened?
What do you mean this is happened?
When this happened?
This happened when we brought the document to Damak and we signed the NOC. After that, from Damak, they transferred the file to the DFC court.
Approximately in calendar time?
2014, we signed, 2015, and we went to transfer in the DFC. And DFC told us, we lost the file. We have a proof from Damak that the amount was fully paid, we cannot transfer the unit. They told us, you cannot do that unless there is proof of payment. And we told them, proof of payment has been given to Damak because there is the NOC signed from his side. We also applied to make a donation, which is kind of agreed. But when we start about donation, it's like, donation, we don't know how to do it. So I say, since he started to act weird, and he's broke his relation with Alliance, because he was using our office, then he disappeared. We never saw him. I thought, we giving a check, manager check 1.8 to him. How we sure that he's not gonna cash it after we broke the relation? Your answer to the question, why I paid Damak? Because me paying Damak, I'm sure I can testify that the money that I was paying was belonging to my client. And the proof of that were coming from my client account in Santo Domingo to Allianz account. and my withdraw was matching all. Withdraw from Allianz, the arrival, and paying Damak. So on that thing, I'm safe. But bring a 1.8 check to this gentleman, and maybe after that he say, does this belong to me? I was completely lost. Till today, I can prove with witness, payment, receiving, bank transfer that the money was from my client and I paid on his behalf from this side.
But wouldn't DIFC registry, they would have registered the property immediately on the spot with that proof, right?
Yes.
And then you were afraid that they were going to take the check and encash it
Of
on the
course.
way out.
Of course.
So that he was going to run and
Yes,
take it.
definitely. That's why we are here. If he was clean, you are not in this case. Like he's trying to steal something that belongs to him.
No, because our position is that because that didn't happen, he didn't transfer.
Position what?
Our position is that the transaction did not take place because that check was not handed in.
Of course.
And that goes in line with all the documents before us.
Okay, but Renata from Damak can testify you, along with witness, that he signed the NOC receiving the full amount. Because Damak is the one who gave the okay to receive and transfer the file to the DFC.
It's
The
okay.
DFC receive it and give the okay. It
It's
was
okay.
lost the file, but we have witness
Okay.
from Damak and from our lawyer.
Thank you very much. I don't
Most
have
welcome.
further questions.
Your Honor, just if I may re-examine just on one or two points. The defendant, can I take you to the page 218, please?
218, sure.
218.
Yes, please.
Yeah. So this is what's called a know your document, know your customer form. And can you go over to page 219? That is your passport, right?
Yes, my passport.
And
Yes.
every time you submitted money to Damak, you had to sign one of a document on page 220, 218, 222, this KYC form.
Yes.
213. Now, every time you're signing this,
Please.
who did you believe you were making payment on behalf of?
Or my client,
And your client being?
VTJ.
Okay, very good. So, just to talk through the MOU, because I think there's been quite a bit of confusion with how the transaction took place. Can you just state in very clear terms, very simple terms, what was the understanding for how VTJ was going to be taking title in the event?
What do you mean?
Let me rephrase that
Please,
question. What was the arrangement between VTJ and the defendant for paying for the property?
No, I still don't understand. Sorry, Mr. Mohammed, sorry. What was the?
How did you understand payment was going to be made for the unit?
Because
How are you going to pay the defendant?
him,
Yes.
cash, as we did in that. His premium we paid him in cash, but I was making the payment on behalf of my client to Damak.
Okay, so let me ask you, you were making the payment on behalf of your client for Damak.
Of course.
Why were you making the payments to Damak directly?
Directly because the payment was in installment over there.
Okay.
So in order to finish it up, they were requested to pay 30 to 40%, then they can resell the unit. After his purchase in March, we signed the MOU in April. I gave the difference to him, and I was paying installment to Damak on his name, but on behalf of my client. And then on transfer date, he got his premium in cash, and he signed the NOC.
Okay, so if I understand correctly, Your Honor, VTJ was paying Damak on behalf of Mohd Ammar because Mohd Ammar was the buyer for the unit?
Yes.
So are you suggesting, what was Mohd Ammar's input in the relationship with Damak?
He put that he was purchasing, I used to resell to my client, he was splitting the profit. That's how he said, was making his premium on top of it. And I was carrying on with all the payment, proving the arrival, the withdrawal, and the payment.
So you're suggesting that he never paid the mark?
Never.
Okay.
He never paid me to pay the mark. If he has any proof that any payment I made to the mark is matching for any of his withdrawal, kindly prove it. I have all the payment to the mark, I can prove all of them, receiving, withdrawing, and paying. If he can tell me where he gave me the money and from where he got the money, please do it. If he has that, let's lose the case. If.
And just finally, I have a question about
Please.
Mr. Chair, do you have any experience with lawyers in terms of Jebel Ali companies?
Not really.
And you've never said, would you count yourself as an expert in terms of dealing with law firms?
No.
And are you aware of the licensing regulations and board requirements for a Jebel Ali offshore free zone company?
I can't know that, but anyways, everything to Allianz, because Allianz was a real estate company. I was a broker, which I was not even legally working, I was representing my client over there. So Allianz is supposed to tell me all the requirements they need, because I was not written in RIRA, I didn't have the RIRA card, so I was acting on behalf of the buyer, not as an agent. The agent is Allianz.
Yeah, that's just, I just wanted to confirm just one last point. You pointed out the paragraph that there was a mistake in your witness statement that payments were made directly into. Sorry, let me just pull up the paragraph for you.
Paragraph 8.
I believe it's paragraph 8. Yes. Now, you didn't have a bank account.
No, I had a personal account, I was not even resident, so sometimes I used to receive 100,000 dirham in the account, the bank was calling me like his personal account, why do you receive this money?
Okay.
So in real estate, everything was going to Allianz Real Estate, always.
Thank you very much.
Most welcome.
Just like a general question to you, do you have any experience with a title deed? Would it transfer from the developer being the mark back over to the registrar? Because we have a certain, some situation, maybe with the mark or another developer, they didn't actually transfer the title deed to the registrar, so that the registrar can issue a title deed for the buyer. Do you have any knowledge about that?
Knowledge, that was my first DFC, because all the property I did in the past was on the freehold, on freehold and free lease, so they were all going to buy an apartment. So this one was my first one. I don't know exactly how does it work that Damak send the file directly to DFC.
So you have no idea about transferring the title deed, the original title deed from the developer to the registrar, then they...
That one is happening after, because we signed the NOC in Damak. Damak sent the file to DFC. DFC finished the transaction and sent to Damak, and we go and collect from Damak title deed. But this is happening after we transfer the unit. But he signed the NOC, and unluckily the file was lost.
Now, this is what if you can help me with understanding what I mean the file of. Did they lost the file of?
Yes, the file that,
Particular unit?
yeah, this particular unit was sent from Damak to DFC, because we cannot collect documents. Once buyer and seller, me, the power of attorney, Theodore Wessing, or VTJ, Mr. Ammar were there to sign, where he signed the NOC receiving the full amount. Damak took all the file, he sent to DFC, and they said they will call you for transfer the unit.
Okay.
When they call us, we prepare the check from Theodore Wessing, the 3.5 plus 18,000 dirham. We went to Damak, and they say, we lost the file. What do you mean? No, DFC, they lost all the file.
Yeah, the Damak sent the file to the DIFC company, real estate registrar, and then the file was missing.
The file was missing.
Now, Damak don't keep any copy of those?
No. But Damak, the person inside, Renata Madlaz, she can testify along with two lawyers that she got this NOC in front of me and he signed it, no objection in transferring the unit as he received the full amount. So we have witness from Damak on the transfer side. not from our side, from Damak, which was intermediator. She can testify, name and surname, Renata. Mad lads. I got
From your understanding, if the file wasn't missing, we found the file, what the file would approve?
File will approve that with the NOC signed from his side, stamped by Damak, that he has no objection to transferring the unit. We were going to DFC with related document from Damak and his signature. We were transferring the unit. That was the process. That's why we prepared the check.
Well, thank you very much. I think witness, he can move now. Yeah.
I can go?
Yeah.
There is any other need for myself?
No, thank you.
Not even tomorrow?
I don't think so. Just today, and I think we've done the rest of it.
Anything else, I'm always available for questions.
Appreciate it. Thank you.
Thank you for your time.
I think now for the respondent call its witness, then after the examination, you can go.
I can see
You can say as you like.
Oh,
You can say. Yes. After the respondent witness examination, the examination will take a break and you will come after lunch for the final.
Could you please state your name?
My name. Yes. Mohd Ammar Al Hassan.
Okay, and what is your religion? Do you believe in?
Muslim. Muslim.
Could you please place your right hand? And put your left hand up. Place your left hand up. I will repeat after me. I swear by Almighty God,
I swear on my
Almighty God, Allah,
yes. I swear on my
Allah,
from Allah
that
that
the evidence
the evidence
that I
I am
about to give
about to give
is the truth,
the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but only the truth.
Thank you. Have a seat.
Hello, Mr. Ammar. Could you please give us your full address in Dubai?
Sorry, Kamal, I cannot hear.
Can you give us your full address in Dubai?
Full address.
Yes, your address.
Jumeirah Village, Circle, Sina building, Sina
Hello?
116.
Very good. How long have you been living in Dubai?
It's around more than 30 up to 35 years.
And what is your profession nowadays?
Managing partner for ACC wireless, and equipment.
Do you over these 30 plus years have you invested in real estate?
Yes, I did invest in real estate.
How many transactions have you done?
It's between 10 to 12 properties. Yeah.
What do you usually do with the properties once you buy them?
Normally, if there is a good return from the rent, I rent it out. Then, or I sell it out in 1 year or 2 years.
When did you buy? We are here today to discuss the retail unit in Damak Towers, as you know. When did you buy it from Damak?
I buy this property in Damak in March 2012.
Why this property back then?
I used to know the manager of Ilias Real Estate. He did introduce me to Zero. And Zero, he told me about this unit. In Damak, there is investment, a good opportunity to invest in this unit. And like this unit will go with the son. I don't remember exactly 7 to 8, but what I remember, he told me up to 1 year installment. But I used to know after that, like 7, 8 months only. Then he guide me like he will manage, he will do the management, this property, he will do like all the payment, all documentation, all paper, everything,
So-
okay, on my behalf.
So he was your agent?
Yeah, he's agent, but he told me this, he will manage, this unit particular, and that he will find a buyer, with the end of this period. Then he will share the profit with me. Yeah.
So when did Zero propose to you to sell it to the claimant, to VTJ? When did he do that?
It was, I end up with the payment, I think in July. Then in August or early September, he told me that his buyer ready to buy this unit. Then we make the MOU in September, I think, of 2014.
Was at the time when you signed the MOU, was VTJ there? Did you meet VTJ when you signed the MOU?
No, VTG never presented. Zero, when he sent the MOU for me, he told me, you sign, then he will do an exchange, he will take this MOU, and then he will sign it with then he will give me on exchange the original again, but he never give me back. But the copy I have, this is copy and this is not original. Because in that time he took the original and he did sign it from VTJ.
So after the MOU was signed, what happened? Did you receive any payments?
Nothing. I didn't receive them.
Any check, any transfer, any cash?
Nothing.
So who was making payments on your behalf?
Zero he was making all the payment
How?
on my behalf.
How?
It's every time I give him cash, or I got by email or I send an email to do the transaction, and I pay cash to him from in our company. There is always cash for business and safety box, and that time in 2011 and 2012, 2013 I did sell 3 properties. So this is like proof of payment that already sold, and there is in land department all documents it's exist and I have.
You were under the understanding that Mr. Zero was your agent, but were you aware of the relationship between Mr. Zero and the claimant?
No.
Would you have appointed Zero as your agent if you would have known the personal relationship with the claimant?
No, I would not. I would not feel protected.
And when did your relationship with Mr. Zero end?
Sorry, come again.
When did the relationship, Mr. Zero was helping you? So when did you break the relationship with him?
It was actually when we finished all the payment, and I remember in July, early August, after he signed the MOU. So after that disappeared. I didn't hear any news. Even I asked Elias, real estate company, that they have problem together, between each other, and they disappeared. And they never heard, from VTJ company for any news, or it's disappeared.
Okay, thank you.
Yeah,
No
thank you.
further questions.
Go ahead.
Mr. Ammar, you've been in the UAE for 30 years, right?
Sorry?
You've been in the UAE for more than 30 years.
Yes.
And you're right now the general manager of ACC Wireless.
ACC Wireless and Equipment.
Okay. And how long have you been the general manager of ACC Wireless for?
Actually, this is a family company,
Yes.
and I am partner with this company.
Okay.
Yes, and I did have my own company alone from long time, from 1996.
How many companies would you say you've been the general manager of or have had as partner?
How many partners I did have?
No, as in how many companies have you owned? Let me rephrase that question. You've been here for 30 years, yes?
Sorry,
Have you been
I
more than-
didn't get the question, if you repeat it again, please.
Okay, I'll repeat it. Okay. I'll try to make it simple.
Fine.
ACC Wireless, which is a family company.
Yes.
How long has that company existed?
How long this company exists? It's more than 7-8 years.
More than 7 years.
Yes.
Okay, so 7-8 years, that would be, so you started the company at around 2010.
Yeah, but I wasn't there with this company that time.
Yes, I understand.
It's only recently,
Yes.
for last 2 years,
I understand.
Yes.
So before 2010, what was your job?
I had my own company.
What was your company's business?
It's my company. It was Eastward Trading Establishment. And I did transfer, this is from 1996, and I did transfer the name 2 times to IREX International. I did change the activities. Then it was the last one, Eastward Packaging.
Okay.
So this is like a 3. I work in all business, in textile. I did work in some packaging, so many.
Okay, so you worked in textiles, packaging, and now wireless technology. Is that right?
Yeah, this is like electromechanical.
Okay, so those are the 3 things: textiles.
No,
Packaging.
that company, only I changed the name, I changed the activity.
But no, okay.
But it was one company. But
Now-
I don't understand what the point is.
I'm going to get to that.
Okay.
I'm going to get to that.
Yeah.
Now, you said that you've owned about 10 to 12 properties over the years.
10 to 12 property.
Over the years.
Yes.
Okay. When did you first start investing in property?
First time it was in 2007.
2007. Do you remember?
Or, okay, are we talking here in UAE in general or Dubai in particular?
I'm talking about the UAE. Let's just say the UAE.
Okay, in UAE, I can say from 2005 in Sharjah, it was the first one.
Okay. So your first property was bought in 2005. You said that you bought some properties in 2007. Now, let me just ask, and this is the reason why I was asking about your job. When you bought your first property, how did you purchase the property? Was it a payment in cash, or did you get finance?
No, some property there is like, if we are talking about the Sharjah, it was with the installment.
Okay.
After that, I was buying mostly in cash. I didn't take anything from the bank.
Okay.
Okay, I generate all my money from my business
Okay.
in the beginning since 1996. Yeah, and all the record
Okay.
it's
So
already in that department.
thank you. So you've been buying 10 to 12 properties in cash. Is that correct? Is that what you're saying?
Yeah, but this is over years.
Yeah, okay.
This is not one time.
This is not one time. This is over a period of from 2005 till presumably now.
Yes.
Okay. So you were quite stretched, you would say, in terms of your finances paying for all of these
It's not
properties.
really. Not really.
Not really. Okay.
Yeah.
So you owned properties in 2007. You said you started buying properties in Dubai as well.
Yeah,
in
of course.
2007.
Yes.
When in 2007 did you start buying your properties?
The first time in Dubai.
In Dubai, yes. Okay, let me rephrase.
2007 in Dubai Marina.
In Dubai Marina?
Yes.
In 2007?
Yes.
Okay. All right. So you would say you're quite experienced in buying and selling properties in Dubai. Is that correct?
Yeah, I'm an investor. Yes.
Okay. your investment. So in 2007, when you purchased this property, how did the price of your properties get affected in 2007, 2008?
That time it was like, let's say, a recession. It was like beginning of the recession or beginning of the crisis. So I took opportunity to buy this unit in 2007 with market broken, yeah. So I did buy this unit,
Okay, so you bought them in 2007 because you saw a financial opportunity.
Yeah.
How many properties do you own today, other than the unit?
Sorry, come again.
How many properties do you own today?
I have today 3 properties.
3 properties.
Yes.
So we went from 10 to 12 to 3, and in 2010 or 12, you had sold 3 units.
7, 8 sold, yes.
Okay.
Yes.
So in terms of a percentage gain, how much of a percentage gain would you
So
say?
I have a copy from the land department.
No, I'm asking you.
I can provide everything.
Yes, I understand that.
Yes.
But my question to you is, you bought in the recession, correct? You
Yes.
saw an opportunity and you bought in the recession. What was your return on investment for these on average, from the properties you bought in 2007?
Do you mean from the rent or from the buy selling?
Just combine them for me, or you can explain both. You can say it's for the rental yield, I think is the term. you
Normally
use.
rental, when I get like more than 8-9%, normally I keep the property, I don't sell. When the rent is drawing down, less of 7 or 6, then I start to think to sell the property. But I don't sell the property very fast. I keep it minimum 1 year to 2 years.
So you weren't in any financial difficulty. That's not the reason why we've gone from 12 properties to 3. That's not the reason why. It's not because you needed the money. Is that right?
I didn't get you. I didn't
Okay,
get
let me talk.
Okay.
You said you owned 10 to 12 properties over a period of time.
Okay.
You bought your first property in 2005 in Sharjah,
Yes.
and you paid installments. And you paid this on money that you had saved with your textile / packaging / well, actually, no, let me read. No, that's not, but that can't be right. So you bought the property in Sharjah in 2005
Yes.
from money that you had saved selling textiles and doing packaging. Is that right?
Yeah. Yeah.
Okay. Now, on an annual basis, in your business, not your investments, just based on your business, how much would you say you're generating on an annual basis, take-home profits?
How much my income yearly? You mean?
You said you owned the business, so you
Can
take home.
sorry to interrupt you. I think this is, those questions very, very general. Let's be more specific with our.
Your Honor.
case. I understand your background or where you're getting in, but let me remind you this is cannot be, this is not the right course to ask those questions. So give a witness very direct question and this directly to the unit we have in this case.
Thank you, Your Honor. So let me rephrase the question then. Why did you sell the 12 units that you so you've sold 9 units to date, correct?
Yeah.
Okay. Now, for those 9 units, how much would you say in terms of percentage have you made on a profit? Have you made a profit or a loss?
Are we talking now about only the
9
properties,
units.
or you are talking about all?
We're talking about the 12 units. You mentioned that you have invested, or from a period from 2005 till now, you have invested in about 12 units. And then you mentioned that as of today, you have 3 units. And you would also...
I have 3 property
You
now.
have 3
Yes.
properties.
Yes, yes.
So 12 minus 3 is 9. Those 9 properties, can you tell me, on average, what was the percentage return for you?
If you know, if you don't know, then
Because I don't know because
That's fine.
because I cannot mix in like sales with the buying with the.
I'm talking specifically about selling, not renting. No idea?
I don't know.
Okay, so you bought 10 to 12 properties, so you're quite used to buying and selling properties. Would you say 35% return would be a very good return on a property, wouldn't it?
You mean with the rent or with the?
that's fine. I mean, I would prefer not to phrase this question because you are giving him an estimation. You cannot give him a 35%. Then he will say yes or no. Move on with your direct question to the unit under dispute here.
So you bought the property, the unit in question, you bought for 1.4 million dirhams, correct? The property. The Ammar Park.
The Ammar
Yes.
property, okay.
You bought that for 1.4 million dirhams, is that correct?
1.410.
1.410. Sorry,
Yes.
my apologies. And is this the first property that you bought from? Is this the only property that you have at this development, Park Towers?
No, I did buy before in I got like in Discovery Garden and in Marina.
No, no, I'm
in
asking
Dubai.
about
You mean in Dubai?
In this Damak Park Towers, the development that they
This is the
use-
first one. with
This is the only one.
First
Okay,
one.
okay. Understood. Understood. And you paid 1.4 for it, and you're saying that you paid for it in cash with money that you keep in safety. Okay. Okay. So, in terms of proof of funds, you don't have that information. As in, like, I can't tell you where did you get that money from.
This is not relevant.
Not relevant?
No.
My apologies, Your Honor. All right, so I'll just move over to your relationship with Allianz. You said that you'd worked with Allianz before, is that right?
No, I didn't work. I was investor. With whom? With Allianz?
Allianz, the real estate.
I never worked there.
You
I was
never-
no broker. I am not Asian.
No, have you used that before?
Use what? They sell for me property. Yes.
Yes, so
Yeah,
they're,
they-
okay, yes, that's what
they
I'm
say,
saying. Yes,
yes.
yes, yes, yes. Yes, okay, okay. That's the point I'm trying to make. Can you just give me a rough estimate, if you remember, how many properties you've sold with Allianz, as in Allianz selling the properties for you?
Yeah.
Do you
Selling
remember-
to whom?
Do you remember how many property you've dealing with Allianz?
Allianz, they sell for me 2 properties only.
2 properties.
2 property, and it was the same time when I purchased this one in Danan.
Okay.
Yes.
Okay. Okay. All right. I think that's okay with Allianz. I just want to ask one last question. Now you said I'm going to point you to some documents. I do not know if you have a bundle.
I mean, if maybe you can bring a bundle or the same bundle. Because you want to read and you want to see. So. We're supposed to prepare one extra one.
Well, I do have one here, but I don't know if the defendant wants. If the defendant doesn't mind, I'm perfectly happy to
I
do this.
don't mind.
Yeah, you can give him an extra one.
Okay.
Thank you.
Unless-
My apologies, Your Honor. The numbering. This is the tabs aren't there, but the pages are numbered. So I'll just be pointing to page numbers, if that's okay.
Yeah. Yeah, help him.
If I could just take you to page 142.
Hey?
No, just at the bottom right-hand corner. Just look for 142. I apologize. The tabs are not going to help.
142?
142, yes.
Yeah, you can have. Is it 142 for me as well?
Yes. It's 142 is always going to be 142, yes.
Well, this is a document in Arabic.
Sorry, let me take you to page 140, the English translation. My apologies, Your Honor. This is a complaint that you filed with the Dubai police. Is that right?
Come again, because my hearing is not very well. This is
140, the English translation.
140.
140. Okay.
Would you rather I speak into the microphone? If you want to hear me better, this is a genuine question.
Yes, sir.
Okay, so you filed this police complaint, is that correct?
Yes, I did follow complaint.
Okay, and do you know what have you been following up on this police complaint?
Yes, we did follow we follow complaint for this one.
Okay,
because it was like I didn't sign here.
Okay.
I didn't sign. Never I did sign, and we went, but the police they didn't accept it because first they need the original. After that they asked me like if there is court already. So they say this is the duties of the court of the DIFC court. It's nothing to. Then later on maybe, but now they need the original, and it's already. I did inform them that it's the court there. So this is why they didn't accept it.
Okay, so this matter has been dismissed, is that correct? The police have rejected your complaint.
No, there is nothing approved. The police rejected nothing. I don't know this.
No, not approved. They rejected.
So they rejected it, that's
They rejected, but I'm telling you what the reason. They rejected because there is no original. It's only copy. So they don't accept. These are the law here and UAE and the police. They don't accept anything if it's not original.
Okay, that'll be all. Thank you very much.
Thank you.
So there is no question regarding this document.
Well, I asked the question, which was, you filed this, and he said yes, he filed it. I asked, has he been following up? And you said yes, he's followed it up. And then I asked, did the police reject this complaint? And you said yes, they rejected the complaint. So I don't think I have any more questions on this document.
The police, there is a difference between reject the claim because there is no crime or just stop the procedure because there is no sufficient evidence. But it seems to me this is unique. I mean, this is submitted by the claimant?
No, this was submitted by the defendant.
By the defendant as it's... Okay. Maybe not.
Actually, but I'm terribly sorry, Your Honor. I just wanted to ask, one more question. Actually, no. Thank you very much. Thank you.
Yes, I only have one question. We've been discussing about the number of properties that you have owned over the years. And it may give the impression after the questioning that you at one single time have owned 10 or 12. But my understanding was that you were buying, selling, buying. So my question to you is, did you own 10 or 12 at one single time?
No.
Okay, that's the only question I wanted to make.
Yeah. Just from the court, if you can
Yes, you know.
clarify that. So when you purchased that unit, you did pay the full amount to Damak. This is my understanding. Did
Yes.
you pay the full amount to Damak?
Yes, I did pay through Zero, the agent.
Yeah, but do you get the title on this property? Have they give you the title deed?
They give me the title deed. I have the original title.
Original title.
Yes.
Okay. So now what's your planning to do with the, thank you very much for your time.
Thank you, Your Honor.
Yes,
Thank
I don't have any further question for you. It's either if you want to take a break now and come back afterwards for the closing statement, or if you want to do it now, up to you. Fine, do you want to take a break?
If that's okay.
Yes?
Yes, it's fine.
How long do you want to take a break? 30 minutes, 1 hour, 30 minutes?
30 minutes is fine.
Okay, we come back for the closing statement then. Thank you very much.
Thank you.
All right.
All right, so we'll continue. I think we have approached the last session of this hearing about closing statement from the claimant and from the respondent. So please, go ahead.
Thank you, Your Honor. Your Honor, today you had the opportunity to hear from the witness for the claimant, Mr. Chiro and the witness for the defense, Mr. Mohd Ammar. The claimant just would like to point out that Mr. Chiro Ariana was the person who had the most overview on this matter. He was the person that, for all intents and purposes, ran this transaction. You have heard from him, and he spoke very, very strongly about his role in this dispute and the facts of the facts of the dispute. The facts in dispute, and that is what is important here. The facts. This is not a matter of law. This matter is one that will be determined by facts. Yes, the claimant is a friend of VTJ Limted, but he is also the person that was getting paid by the defendant for the sale. He was receiving his commission from sales commission from the defendant. The defendant hasn't denied that Chiro made payments for Damak. What is in contention is where that money came from. Our claimant argues that it provided the money. The defense argues that it provided the money. In such an instance, with the benefit of hindsight, and looking at what actually happened, as was argued by Chiro, it is the claimant's contention that Mohd Ammar received payments for a property that he owned only in name, and that he has taken this money and is now unjustly enriched. He has, in essence, gotten a property for free that he's now going to be renting out. He's met with our client and has demanded payment in excess over what was agreed. The defendant hasn't exactly identified where the payments were from. They point to transactions that had occurred on the year that he had met with VTJ, the claimant, but has neglected to evidence that. The evidence that was presented today in terms of land sale and purchases from RERA or the Dubai Land Department should have no relevance in this matter. They weren't provided to us and they should be excluded. And more importantly, we have put forward our statements. We have explained where the funds came from. We have attempted to evidence that. The defendant hasn't provided any evidence showing otherwise, stating otherwise. All we have is his word. And of course, in a matter which relates to his personal property, his testimony is going to be biased. And it's going to be in the, he's going to be stating things in a matter that puts what he said to the best evidence. The claimant is a neutral party in this matter. He had nothing to gain from bringing this matter to court. He had nothing to gain from coming to court here. As far as the witness is concerned, this isn't his property. There's no reason for him to be here. There was, and the reason he did come here was because he saw that there was an injustice that was going to be carried out. That Mohd Ammar was going to take a property that he paid nothing for. He tried to elicit more money from his from the claimants, and now is benefiting from the fact that everything on paper is in his name. The court cannot and should not allow that to happen. And the claimant submits that the evidence it has provided shows that there was an agreement. Even if the agreement in the MOU, even if the agreement was what is in the MOU, the defense has talked about how the payment terms in the MOU do not match up with the payments that were actually made. The claimant submits that that is inconsequential. The agreement and the conduct of the parties showed that there was a binding agreement. The seller, being the defendant, had agreed to sell, and the purchaser, being the claimant, had agreed to buy. The claimant wired money to the accounts of Allianz, who the defendant had some dealings with. And that money was then given to the developer, Damak Park Towers Company Limited. Was given to Damak Park Towers Company Limited by the agent. Now, of course, all the documents are going to state that the receipts are made out to Mohd Ammar. They will, because as far as the developer was concerned, and until the time that the claimant attempted to transfer the property, the world at large saw the defendant as the owner of the unit. That is what had happened, in essence, with the benefit of hindsight, looking at the conduct and looking at the actions that have taken place between the parties. That is the only explanation that is possible. Now, we had mentioned risk, 1.8 million. Why would we give a manager's check for 1.8 million? It's actually very, very simple. The simple matter is that the claimant, the defendant, had property as security for the obligations of the claimant to make payments on its behalf to the bank. The claimant, the defendant talks about how he would never sell within, he had mentioned that he doesn't sell within weeks. The claimant submits that that is unlikely to be the case, simply because he had purchased the property on paper for 1.41 million euros. The claimant had offered a payment of 1.876,750, the amount. That represents a net gain of about 30%, 30 to 35%. It seems to me, and I would submit, that faced with such an offer, the defendant had made up his mind that yes, he was going to sell this property, and that is how much money he was going to get for it. In essence, it is the claimant's contention that it complied with all of the obligations that could be reasonably be placed on, either by way of the MOU or by the agreement that had occurred by conduct. And in terms of the agreement by conduct, it has the three things that are required as per the Chief Justice in the Mount Park Towers versus Yusuf Nisawar, in that it has the verbal argument or the agreement by conduct has a specific purpose. There is a specific named property. The parties are identified, and consideration is identified. The parties are the defendant and the claimant, and the property is the unit, and the price is 1.875 million euros. If the court is to entertain the arguments that are put forward by the defendant, then that has to be the fallback position, that there was an agreement by conduct, and that this agreement, through the actions of the defendant, with the actions of the defendant, the claimant has no realistic prospect of ever achieving the aim of the agreement, which would be title and property, and that Mr. Ammar has threatened has made threats or demands for additional payments, simply because he identified that there is a situation where he can, in essence, extort more money from the claimant. He has come to the realization that, yes, the documents name him, but that is only because he refuses to transfer title. He had refused to transfer title. So what he has basically done has taken a property that he's paid nothing for. He is renting it out now to a third party that we do not know, and has effectively gamed the system. He has taken advantage of the fact that the claimant is not in the UAE, is taken advantage of the fact that there are no documents that state the name of the claimant on, and is now profiting off of that lack of documents. So, for these reasons, the claimant must be entitled to either the unit under specific performance as per the terms of the MOU, and if, for whatever reason, the MOU is not accepted as a legally binding agreement, which the claimant holds that it does, then the claimant should be entitled to have the agreement be terminated, and to have all payments that have been made by it on behalf of the defendant paid to the developer as restitution. And I will close just on one final point. The agreement the defendant has talked about, there are a lot of inconsistencies with what had happened, the conduct of the parties, and what is stated in the agreement. But at no point did the defendant notify the claimant and say, to notify the claimant and say, well, time is of the essence, for example, with regards to payments that were made with regards to the defendant's arguments about the different times. At no point did the defendant say, you need to pay this, there's X amount of money missing from payments that are due. At every point, the claimant had provided funding. At every point, payments for Empower, payments for facility management, payments to the MAC directly. The documents show that the agent paid for these things, and the agent is an impartial party, regardless of his personal relationship with VTJ. He is the neutral person, and he is the party that has the most direct view of the events that occurred leading up to this dispute. And it's for this reason that we think that the testimony given by Mr. Arya should be given a full weight, a stronger weight than the arguments that have been put forward by the witness statement of Mr. Mohd Ammar. And of course, I repeat the arguments that I put forward in the skeleton arguments that Your Honor takes a view of those arguments as well. Thank you very much.
Yeah, thank you. Just to clarify this before we move to the respondent. The claimant position is, just correct me, the claimant position is all those money transaction or paying for the unit pricing goes to the MAC from the agent or from the alliance. So I get confused a little bit.
Yes. What the claimant is contending is that it would send money from one of its various bank accounts in jurisdictions that are more tax favorable than Italy. They would send those funds to the account of Allianz, the real estate company, who would then withdraw that cash and hand it to Chiro, who at the time was employed or a partner with the principal at Allianz, who would take that money and then deposit it in the MAC on behalf of the defendant. On behalf of the claimant, but the claimant had assumed the payments of the defendant due to the developer, the MAC.
All right. And that was 1.8 something. I mean, the claimant position, they paid 1.8.
The claimant's position is that they paid 1.8. That's right.
To the MAC through the Allianz through
the claimant had paid 1.8 in total, of which 1.41 million went to the MAC, which was the original purchase price, and of which the remainder was given to Mr. Ammar as his as the agreed selling price, his profit margin, the profit he made on the property. He bought low, sold high.
And we don't have any sort of documentation in terms of emails from Allianz to the claimant confirming that the full amount has been paid on behalf of the claimant. We don't have any such of.
Unfortunately, we do not have such a document, and when we had applied to...
And each, because those installments or those payments, as you alleged, or the claimant argue, has been made through a period of time?
Yes.
6 months?
It would have been a period between 2012 and 2014.
All right.
A period of 2 years.
So in each time, I'm following your position, each time the claimant paid for this unit through the Allianz, through the agent, I'm assuming that after each payment, the claimant is supposed to receive kind of confirmation of payment, like installment 1, installment 2. The claimant never received any kind of those confirmation?
Unfortunately, I haven't been advised as such. I have not received instructions on that.
Right. And even the bank is not acknowledging that they received money from, the bank acknowledging they're receiving money from Allianz.
The bank has acknowledged that they received money from
Mr.
Arian.
Under his name, but the money is coming from cash, I mean, from the agent.
And I will just note that you raised, if I may.
Yeah.
He's paid all of these things in cash and has not adequately disclosed where that cash came from. It's one thing to just say that
You mean the witness, the agent?
I mean the defendants.
The defendant.
Yes.
But I'm not in that part. The part is the agent, your witness name, the agent, when he paying the MAC in cash, did not, of course, there's no requirement or whatever on him to verify to the MAC this is where did this money come from.
He's not under an
So
obligation.
the MAC will assume this money came from
The defendant, yes.
the defendant.
Yes.
And no any question on that. I mean,
No.
the bank never questioned this money comes from defendant or this is coming from Allianz on behalf of the claimant,
That's correct, Your Honor.
right?
That's correct, Your Honor. Receipts were issued as they would be.
Under the name of defendant.
That's correct, Your Honor. And I will just point again that the documents provided specify an address in Jumeirah Village Circle, whereas the documents we have before us, which we hold to be the originals, specify an apartment in the Zamadora building in Zabil, which corresponds to the document that is provided in the bundle at page, I believe, 202, which is the market agreement to sell between the defendant and the claimant. So we do have the receipts, so there is payment confirmation, but that's not in debate.
Yeah, that's not helping that much to prove that the money came from the claimant. Those receipts, right?
No, it does not hurt.
Now, just from my experience in some situation where if you reserve a unit and someone else has interest in this unit within the DIFC in terms of another cases where I'm glad you can work, for instance, there is something called caveat form, and somebody put like the funding or the person who's funding the units, they sign or they put their name under the form of reservation form, and there's the caveat where the person or the company say, I have an interest in this, and this has never happened in this scenario.
Not that I'm aware of, Your Honor.
Yeah.
Although, Your Honor, I will just point to one thing.
Yes.
Yes, you are of course correct that caveats are possible, but I would, the fact that we are dealing with an inexperienced agent, he himself had stated this is the first DIFC transfer that he had done, I would put that down to the fact that he was not aware that you could even do that. That is not an excuse, but
Yes.
it's just
But understand. But the claimant itself have done some investment in the IFC, right?
No, sir.
No.
No, Your Honor.
This is the first. Okay, I just want to clarify my thought. My thought is useful to explore those things for you, so you understand where I'm standing and I'm thinking. Thank you very much.
Thank you, Your Honor.
Sorry, before do you have anything regarding the counterclaim? Unless
well,
you have another.
There is just, sorry, yes, thank you, Your
Yes.
Honor, thank you for reminding me. With regards to the counterclaim, the claim is made for a deposit that was held, that was allegedly made to Allianz Real Estate. The claimant claims that they are not the correct party to go to claim against with respect to this deposit. That deposit, if it was paid, if the MOU of 9 September 2014 is found to be a binding document, which the claimant claims it is not, simply because there was no, either in fact or by conduct, there was not a meeting of the minds, there was no offer there was no agreement between the parties, and the conduct indicates as such. And the document to which they refer to is an unexecuted agreement, which has no binding effect. And therefore, their claim that they're entitled to some deposit under an agreement that, by operation of law, in fact doesn't exist, means that the claim should be dismissed. And if it isn't, and if the court finds that there is adequate reason to believe that the agreement, there was an agreement in place, the claimant would submit that it is not the correct party that agrees to the claim, because the deposit is being held by a company, Alliance Real Estate Limited.
Just before we move on, what's the position of the claimant to clarify the reason for sending money to the Alliance, then Alliance will give cash to the agent and give it to the man instead of paying directly to the man? This process gone?
From Your Honor, I haven't been instructed, but I can give you my opinion on that matter. VTJ Limited is a Jebel Ali offshore company, and it did not have a bank account in the UAE. It was buying property from the seller, but it had a reason to want to have a middleman handle the money. And there would be nothing preventing the defendant. I would imagine this is their rationale. There's nothing that would have prevented the defendant from taking the money and doing something else with it. So they would have rather have sent it to VT, to Alliance. They had, this is a registered brokerage, which is licensed and is subject to regulation, so they would send it there, and then it would be withdrawn and then handed over in cash. It was a matter of security, I would imagine.
Thank you very much.
Thank you, Your Honor.
Yes.
I will be very brief. Claims need to be proven. Unfortunately, the claimant, or fortunately for our client, has not proven its claim. All evidence that they are trying to rely on is the same documentation that has allowed DAMAC to stamp a payment completion certificate and issue a title deed on behalf of our client. Mr. Ciro was not someone else's agent. He was our client's agent in the eyes of DAMAC and in the eyes of our client, and made payment on behalf of our client. This is what the file shows, DAMAC's file shows, and the registry shows. Pursuant to this, and for the sake of legal security, that any system needs, the claimant's claim needs to be dismissed. We seek our counterclaim, and we seek the 75% of the deposit deposited. It was not encashed. Our understanding is that there was a security check deposited with Alliance that was not encashed. The rationale behind it is that if we go to the MOU, page 178, Your Honor may notice that the price is 1.8, and in clause number 2 it says that the claimant would pay 1.8 on the day of transfer. Okay, and 180,000, the check, would be returned to VTJ, to the claimant, only if the seller or client withdraws from the transaction, which was not the case. So it's not an amount that was paid to Alliance. It was a security check that was never encashed. If we go to paragraph number 9 of the MOU, it says that in the event that VTJ withdraws from the purchase, the first party or client, the defendant, has the right to keep 75%, and 25% will be kept by. So in such case, would VTJ be entitled to encash the check? Okay, it's not our understanding that the check was encashed. we have no record. So the claimant's claim should be dismissed for lack of any evidence, and our client, the defendant, is entitled to the counterclaim, 75% of the deposit in the amount of $36,000 plus legal costs in the amount of $63,000 US approximately. Thank you very much, Your Honor.
Yeah, thank you very much. I want to verify my quote here. So, the defendant gave a security check to Allianz.
The claimant.
The claimant gave.
Mm-hmm.
And I'm getting lost here.
Yes.
The defendant claiming $36,000 US. For what exactly?
Is the 75%?
Yes.
There is a security deposit which was $180,000.
And that wasn't in cash.
180,000 dirhams. That was not in cash.
So where is the harm here then? So where is the loss?
No. There is, but this is the penalty in the event that the claimant withdraws from the transfer. Our client never received any funds. So
Yeah, I'm trying to find where is the defendant lost in terms of the claiming amount. So you claiming 36,000.
we are claiming in line with the MOU and clause number 9 of the
I claim
MOU.
the penalty.
The balance, yes.
You claiming the penalty.
The penalty, correct.
Right. Another clarification. Defendant received a title from the MAC, not from the real estate registrar in DIFC. Is it correct? I mean, does the DIFC registrar issue a title for the defendant, or just the MAC give a title to the defendant?
We have the registry. We have the registry title.
You have a registry?
Yes. It is in
Yeah. Definitely.
in page 294 of the trial bundle, the very last document.
Okay, I think I have a. Yeah, thank you very much.
Thank you.
I think I have a good understanding about this case. Does any of you have submitted any cost estimation for what any of you, or this is will they will later on? The legal cost never been submitted, right? The legal cost.
I believe we have submitted.
Your Honor, I believe it has been submitted.
Yes.
Yes.
I believe it's contained in the case management conference.
Yes.
Correct.
But not in detail. Is it in detail?
But not in details,
Yeah.
no, Your Honor. Not
Then I think this is the end of it. I will reserve my judgment of course for a couple of weeks, and we'll issue it within that period of time. Hopefully, before end of May. We'll take it from there. Thank you very much for what you did.
Thank you.
All rise.